Alrighty, so this is OER and copyright, kissing cousins, not adversaries. So I am Lisa Malcolm. I am a PhD candidate at the University of Western Ontario in the law faculty. I'm also a lecturer at King's University College and also Brescia University College, which are affiliates of the main campus. My basic premise with this particular presentation is that copyright, like all intellectual property, is based on the premise that the education and hard work that goes into creation should be rewarded, and that creation should be made available for further creation. So there are a lot of synergies between OER and copyright, but I know when we're talking about open educational resources, people often, sort of raise the specter of copyright and avoid all materials that might be considered to be in copyright or are in copyright. More to the point. So just a few things about today's talk. I thought I'd start off with just a little bit more personal background. So I do have a JD in intellectual property and information technology, and I earned that at the University of Western Ontario in London, Ontario, which is about 2 hours west of Toronto. So the fake London, not the real London. I did an LLM in entertainment and media law in Los Angeles, because where else would you go to study Hollywood but Hollywood? Then I came back to Western, and I'm now trying desperately to finish my PhD while also lecturing in business law at one of the affiliate colleges and lecturing in writing at another of the affiliates. So my PhD actually looks at digital content delivery and how that is challenged by the entertainment and media industries and how that affects access to culture, and also access to justice issues as well. My focus is primarily on Canada and the US, because you are asked to take a reasonably narrow focus for your PhD. But I often, drift out into the wide world because we kind of have to. And as I hope will become clearer in this through this presentation, if it isn't already to people, we are all basically in the same boat with Mickey. So one of the drawbacks to being on in hour 36 is that a lot of what I had planned to say has already been said, and a lot of it much better than I could say. So I'm hoping that a lot of my remarks are really just going to be sort of reinforcing things that were already said. So I'm going to talk a little bit about understanding what open actually means. I'm going to talk about how copyright's history supports OER in many countries, because when I'm talking about copyright's history, I'm really talking about the history that comes to those countries that have been influenced by the UK. So North America, but also India, and Australia and some other countries as well. But I'm cognizant, of course, that there are other systems out there as well. I'm going to talk about how to use copyrighted material. I'm going to use a Canadian example from what happened at Western when COVID hit. And I'm going to talk a lot about sort of broad lessons that were learned from COVID and through our experiences there. So what OER actually means to me and comes to me from a number of different angles. So one of the things I think it's really important to understand going in is understanding where pushback to OER comes from. So there's institutional pushbacks, and I unfortunately felt that quite a lot on my campus. Our libraries were not terribly supportive. They allowed us to have access to the Hathi Trust, for instance, only while we had no access to the libraries. And once we were sort of back on campus this fall, our ability to access the Hathi Trust was taken away. The libraries in Southern Ontario universities have actually also now joined together in what's called the Omni system. So we can all sort of share our own library materials through all of the different universities in Southern Ontario. And that's the kind of system that I would really like to see expanded beyond Southern Ontario, right? Certainly a lot of universities have synergies with other universities in other countries, and it would be great to start to see more of that happening. One of the other institutional pushbacks, and this goes back far beyond or before COVID, is a very risk-averse legal team and administration. So again, I mean, they're doing their job. I'm not trying to, criticize them or anything. That is what lawyers are supposed to do. They are supposed to be risk averse for their clients. And when the client is the university, they're going to be risk averse for the client, the university. But that doesn't mean that our corporate lawyers helping with administrative issues at the university actually understand the nuances of intellectual property per se. So that's a bit of a problem. The other pushback, of course, is industry. There's also teacher and professorial pushback, right? So when people prepare lectures and things, there's a concern over, my copyright in my intellectual property with my lecture material. And of course, that's something that we can also all relate to. We spend a lot of time producing that. I'm very lucky to work in an institution which agrees through our contract that my intellectual property belongs to me and not the university. But what that also means is that I can then assign Creative Commons licenses to my things and make them freely available. There's also a push to add our intellectual property to the university database and make it available to students in that way. And that is one way that our institution does support us. So industry pushback, and when I talk about industry pushback, I'm talking about, of course, the entertainment industry, the media industry. So the Motion Picture Association of America, the recording industry of America, the large publishers, especially textbook publishers, and they all have pushed back through the USTR, the United States Trade Representative. And they affect all of us all the way around the world through lobbying. And that's not only lobbying for changes to legislation in the United States, but when the legislation in the United States changes, they're also lobbying for those things to go into trade deals. And that's where we get, TRIPS plus things added to trade deals, and that then affects the broader world. It's all part of larger access issues. Education is, of course, more than just what happens in schools. There's lifelong learning that we hope continues past school as well. It's important to have access to culture and history, which is also factored into access to justice. So these are all issues that also factor into how we have access to our digital materials that may be restricted through the work of the media industries. So there's this need for us to win over those who have perhaps misunderstandings, who are perhaps skeptical about how OER may affect their bottom line. So I feel that it is important to be able to couch those issues in a way that Steamboat Willie is going to be on board with and help us move forward. So the UNESCO definition of open educational resources is our teaching, learning, and research materials in any medium, digital or otherwise, that reside in the public domain or have been released under an open license that permits no cost access, use, adaptation, and redistribution by others with no or limited restrictions. So there are a lot of words there that also come up in, fair dealing and fair use exceptions in copyright law. And I would also say that, we shouldn't just be thinking about just public domain or open licenses. There's certainly carve-outs under fair use and fair dealing in the countries where that's available, that these materials can also be factored into OER materials. So some of the misunderstandings that go along with open educational resources. So open doesn't mean piracy. And I apologize for the violence of this cartoon, but it's pretty perfect, right? So, file sharing, once you buy something, it is yours to share. That's the first sale doctrine. But entertainment and media industries are very good at creating spin, right? They're very good at saying, it's piracy. They like to put a name on it. Like everybody doesn't want to be a pirate. I mean, we all speak, like pirates during Pirate Day, etc. It's important to watch how they're spinning the language and try to combat that. and to try and soothe them with the fact that, open isn't stealing. Nobody's trying to get something for free. Now, when I say education doesn't have to mean free, that means that, just because students pay tuition, that doesn't mean that education or universities are a for-profit endeavor. Okay. Sadly, sometimes it does seem like we're going that way, but for most of us, education is a means and an end in itself. Research isn't just for scientists. Okay, it's absolutely legitimate research to check out ringtones before you buy them. And there's a very famous Supreme Court case in Canada that supports that as a fair dealing use. Okay. Nobody's going to want to buy a ringtone without actually getting to hear at least a snippet of it. Research doesn't have to be done without profit. And one of the foundational Supreme Court cases in Canada, CCH, is actually about a case in the law library where cases were photocopied for lawyers doing research for cases for clients. And that was considered to be fair dealing. And where fair use and fair dealing is available, there are more options to people when it comes to OER. So just a couple of things that are going on that I really wanted to point out here. Research really is an integral part of education. And there's a right to research project that is going forward at American University, Washington College of Law. They've put out a whole bunch of really terrific resources that I would definitely point you to. And this, again, also factors into things that are happening right now, right? So there's this proposed TRIPS waiver at the World Trade Organization, and the TRIPS waiver is a proposal by South Africa and India to temporarily waive trade obligations to protect intellectual property rights in instances where necessary for the prevention, containment, and treatment of COVID-19. And it's supported by most countries in the world, but it's opposed by a small group of wealthy countries. And I think we're starting to see the fruits of that particular labor in the Omicron variant, which is starting now, right? So if we've done more, and I count Canada in this because Canada has been opposed to the TRIPS waiver. If we had done more to get vaccines and to allow for better production of vaccines in South Africa, we probably wouldn't be where we are today. But that's speculation. All right. So the UNESCO recommendations on OER, and I know we've all seen these many times, but building the capacity of stakeholders to create, access, reuse, adapt, and redistribute, those are going to, again, be keywords that come up when we start to look at fair dealing and fair use. Developing supportive policy for OER. And there's a public interest goal with copyright that runs right through it. Encouraging inclusive and equitable quality OER. And again, these are access to culture and access to history issues that come up. Nurturing the creation of sustainability models for OER and promoting and reinforcing international cooperation in OER. So a lot of these things are reinforced in copyright as well. So the upside to COVID was that it really focused our attention on the need for open educational resources because suddenly most developed nations got a little taste of the problems that are faced every day by developing nations as we moved online. Suddenly we didn't have access to our huge libraries, et cetera. We couldn't just go and buy a new textbook at the bookstore, although we quickly pivoted to have them delivered to our door. So what happened, of course, March 13th for me in 2020, in-person instruction went online. Suddenly people were very unsure of what they were doing was okay from a legal standpoint. 99% of the time it was, but many people had to pivot at that point. And we learned a lot of lessons, not just in the educational sector, but in a broader context as well about what was going on and so on. One of the things that happened for me personally was we had a whole bunch of seminars on how to use Zoom, for instance. And I also helped myself and my supervisor, Sam Trusso, helped by doing a seminar on copyright and why people didn't have to worry because what they were doing in an educational context, sharing scholarly articles with their students, perhaps uploading chapters of textbooks. All of those things were okay. And it was perfectly okay to make those available to your students. It was legal if you were in the classroom. It was legal if you were online and your classroom was online. The other thing that unfortunately happened was COVID fatigue, of course. And I think we're all maybe suffering from that. So again, this was a schematic literally that I took out of that particular presentation that I did. And this showed basically localized school closures right at the very beginning in March of 2020. And of course, that has only increased. If you're interested in seeing more up-to-date schematics, they're all on the UNESCO site. It's very well documented. So the guidance that we tried to provide for our fellow teachers, again, as I said, practices acceptable in the traditional classroom, acceptable for emergency remote teaching. And it's not just simply online teaching. There was a real public interest to doing it, right? But it's not just applicable as well to emergency remote teaching. The practices that we use throughout COVID can apply to a wider OER. I think we became more comfortable working without the net of a textbook, perhaps. Of course, a lot of these lessons are subject to national copyright laws. And again, I will just mention that my presentation is basically couched in the two systems that I'm most familiar with, and that's the US and Canada. But of course, the US has a lot of sway elsewhere as well. So we got a good sense, I think, of what worked and what didn't, both in online teaching and in open educational resources. And we also created a lot of open educational resource materials over the last year and a half. So one of the things that we tried to reassure people about was that we use copyrighted material every day. It's already available to you. But there's also a number of things that are available that aren't copyrighted, okay? And there's no need to start a copyright analysis at all if you're using things that you gathered through your library database, okay? Those are freely available to us, assuming you have a good library database, and I refer you back to my comments about the Omni system here in Southern Ontario. If you have open access materials, okay, or if you have public domain works. So, you know, while there are a lot of works available to us in these areas, you shouldn't discount using something just because it is copyrighted as well. So I just quickly wanted to sort of say, you know, give a brief shout out to the public domain, right? So works that are not covered by any intellectual property rights are those in the public domain. So for copyrighted works, when the copyright expires, it's then in the public domain. So the duration of copyright is life of the author plus 50 in Canada. Works for hire or corporate works are 95 years after the first publication. Most countries do have their copyright statutes available online. It's always a good idea just to double check what your statute says about these things. I will also mention that life of the author plus 50 in Canada will soon be going up to life of the author plus 70 due to the USMCA or the CUMSA. No, wait a minute, CUSMA. Depending on where you are, it has a different name in every single country that it's part of. It's the North American Free Trade Agreement, the new version of that. So again, this is another way that the US is able to push us all in the direction they want us to go. So just looking at what is copyright, and I'm going to use the Canadian Copyright Act to illustrate. In Section 5, Sub 1, it says, subject to this act, copyright shall subsist in Canada for the term hereinafter mentioned. That would be life of the author plus 50 years. And every original literary, dramatic, musical, and artistic work. So copyright, and this is pretty standard, copyright is the intellectual property right that attaches to an idea when it is expressed, okay, or fixed in a tangible form. Okay, so a book, a photo, a film, a lecture, article, a recording, a TikTok, a YouTube video, all of these things have copyright attached as soon as they are fixed in that tangible medium. They don't need to be registered. As soon as they're fixed, that establishes copyright. Registration is good for a number of different reasons. If you're in the US, if you actually want to sue somebody, you do have to register your copyright. Not the case in Canada, but there are other advantages to registering, but this isn't actually a talk about copyright per se. So again, for the purposes of this act, and again, this is pretty standard. This is a Canadian act. This is Article 3, subsection 1 and following. Copyright in relation to work means the sole right to produce or reproduce the work or any substantial part thereof in any material form whatever, to perform the work or any substantial part thereof in public, or if the work is unpublished, to publish the work or any substantial part thereof, and includes the sole right to produce, reproduce, perform, or publish any translation of the work. Okay, so some of these things should already be twigging about OER, right? The whole reproducing, etc. Just jumping down to E, right to reproduce, adapt, and publicly present, communicate the work to the public, and to authorize such acts. So a lot of these things are things that we do when we're working with open educational resources. So it's also important to understand, though, that while copyright is regulated by federal statute, it's also important to understand that we're guided through the way the courts interpret that legislation. So the Supreme Court of Canada and, of course, the Supreme Court in the United States have the last word on how those things are interpreted there. So copyright doesn't protect things like ideas, facts, data, concepts, systems, methods, principles, discoveries, okay, names, titles, short phrases, okay, all of those things, no copyright. And this is where we take a deep dive back into the history of copyright, because I think it's really elucidating to understand, where we're coming from and to where we're going. So copyright is grounded in education and access, particularly, as I said, in North America and many other British colonies, because they begin their history with the stationer's monopoly of 1557. So the intention of that particular legislation was to give the publishers complete control over the works they copied in an attempt to prevent seditious writings. It was actually a form of censorship, okay? We jump ahead to 1710 and the Statute of Anne, and this is really the first Copyright Act. The complete title was an act for the encouragement of learning by vesting copies of printed books in the authors or purchasers of copies during the times therein mentioned. So it was a very limited monopoly, 14 years. And if the author was still alive, another 14 years. It was meant to benefit the authors and the users, right? Authors and purchasers. And the intention was clearly to benefit the author during their lifetime, okay? The statute also sought to at least blunt the pernicious effects of monopolies that had been occurring previously. So what had happened to move this was that society had moved from this Renaissance belief in divine inspiration, that God simply spoke through authors, to the humanist belief in the power of the authors and the creators themselves. However, there's another valuable lesson that came out of the Renaissance as well. Okay, education from the earliest grades largely followed the classic traditions of rhetoric, which placed a strong emphasis on the imitation of the classics in order to master the material. This system of education was prevalent through the early 20th century, and forms of it are still taught today. Okay, though coming from a different tradition, education in China, for instance, is also firmly grounded in imitation and repetition, to the extent that many Chinese international students at Western universities struggle with the very foreign concept of plagiarism. So the Statute of Anne also recognized the need for education for creators and authors to learn their craft. In addition, still grounded in the traditions of classic rhetoric is the belief that a strong democracy requires an educated populace. Indeed, this belief in the importance of an educated populace to support democracy was the driving force behind the Federal Communication Commissions in the United States mandating that basic television should be available for free for all citizens. The Statute of Anne is also concerned with ensuring access to works. So Section 5 of the statute states that 9 copies of each book or books upon the best paper that from and after said 10th day of April 1710 shall be printed and published as aforesaid, or reprinted and published with additions, shall by the printer and printers thereof be delivered to the warehouse keeper of the said company of stationers for the time being, to be distributed to the libraries at the universities of Oxford and Cambridge, the libraries of the 4 universities in Scotland, the Library of Sion College in London, and the library common called the Library belonging to the Faculty of Advocates in Edinburgh, respectively. So this practice of submitting a copy of a work to the Library of Congress as per copyright registration in the United States has a similar purpose, right? On the Library of Congress website, it states that the library preserves and provides access to a rich, diverse, and enduring source of knowledge to inform, inspire, and engage you in your intellectual and creative endeavors. So copyright's traditional tension then between providing incentive for creators through monetary reward and providing access to works to further innovation and creation and innovation, and what the creative process really entails. So having access to culture and education through which to learn a craft are crucial and valuable parts of the process. So COVID also has this public interest element to it, right? And public interest and copyright is well established, particularly in Canada through the Taberge case, right? Copyright should provide a balance between promoting the public interest and the encouragement and dissemination of works of the arts and intellect and obtaining a just reward for the creator. And in CCH, which I've already mentioned before, right? They stress that it's a user's right, they stress that research must be given a large and liberal interpretation in order to ensure users' rights are not unduly constrained. So a lot of the same things that are coming up in the past are still present with us and do support OER. So if we go all the way back to the OER definition, right, it says, you know, online or in any form, right? We're talking not just about online education. So I wanted to just briefly mention, you know, technological neutrality, and that is central to copyright, understanding copyright as well. This is also well established in Canadian law and Canadian courts, in Entertainment Software Association versus composers. The court's decision balanced the rights of owners and users by not requiring users to pay more for the same content, which was being delivered by different technological method, and when they chose to buy a video game online rather than a physical copy. So the central issue of this particular case was that the SOCAN, Society of Composers, Authors, and Music Publishers of Canada, felt that an additional royalty should be paid for video games that were sold online, even though the royalty had been paid when the video game was created for its physical sale. Okay, and that's the court said, doesn't matter, physical, digital, same difference. You pay, you got your kick at the can, you're done. So principle of technological neutrality requires that the Copyright Act apply equally between traditional and more technologically advanced forms of the same media. And this is also, you know, part of the basis of the Sony Corps of America, which established that taping a TV show and playing it later was simply time shifting and not actually copying. And I'm just going to jump ahead a little bit just for the sake of time. I'm not going to spend a lot of time breaking down fair use and fair dealing per se, but I will also mention here, actually I'll mention it coming up, another resource from American University. But just to compare fair use and fair dealing a little bit, there are exceptions to copyright infringement. Okay, they're considered to be a user's right as opposed to a defense per se. And one of the things to concentrate on is the purposes that fall under that fair dealing. Now, fair use in the United States includes a list, an illustrative list, right? For purposes such as criticism, comment, news reporting, teaching, including multiple copies for classroom use, scholarship or research, and those are not infringement. Now that's an illustrative list. That such as means that anything that sort of sounds like those things, is similar to those things, is still going to count. For Canada, we have a closed list. Okay, so fair dealing for the purpose of, and it's research, private study, education, parody, or satire does not infringe copyright. We have a few other exceptions that are added on, and I'll talk about one of those in a minute. But the important part here is that we have research, private study, and education. Okay, those are the big ones. We also have news and criticism as well as separate. But those are the big purposes. So then we have the 4-factor test in the US, okay? So they look at the purpose and character of the use, okay? Whether it is for its commercial nature, for nonprofit, educational purposes, it's right there in that first factor. The nature of the copyrighted work, amount and sustainability, and the effect of the use upon the potential market or value of the copyrighted work. So essentially that fourth one often breaks down to, well, is it really competing in the marketplace, right? Is this a complete substitute? We'll talk a little bit more about that. Now, the fair use factors in the US, of course, are right in the statute itself. In Canada, our 6-factor test actually comes to us through the CCH case. So it's actually not entrenched in legislation, but it's still used by the courts because, of course, it was endorsed by the Supreme Court. So again, we look at the purpose, but we break purpose and character down into 2 factors. So purpose is one, character is another. Then we have the amount of the dealing, alternatives to the dealing, nature of the work, and then the effect of the dealing on the work. So further exceptions in Canadian copyright, and this is one that we're super proud of, and we're hoping isn't going to get kiboshed, and that's non-commercial user-generated content, okay? Sounds a lot like OER to me. In fact, this was brought up in one of the other sessions, that user-generated content is a big part of OER, right? So we actually do have an exception for this. Now, it's great as far as it goes, right? If we look at the factors, and here we do have a 4-factor test in the legislation, use of and authorization to disseminate the new work or other subject matter solely for non-commercial purposes. Again, remember that just because you're charging tuition doesn't make education a commercial purpose. The source, if given the source, the name of the author performer, so you need attribution, okay? You had to have used a non-infringing original copy to create further from your user-generated copy. Now, where it falls down a little bit is, I will admit, this 4th factor. The use of or authorization to disseminate the new work or other subject matter does not have a substantial adverse effect, financial or otherwise, on the exploitation or potential, on the exploitation. So up to there, that's pretty much the same as we've seen elsewhere. But then we get potential exploitation of the existing work or other subject matter, a copy of it, or on an existing or potential market for it, including that the new work or other subject matter is not a substitute for the existing one. So really anything that they could have possibly thought of then gets sort of thrown out. So it falls down a little bit on that last factor. So quickly, what is fair dealing? How do we apply it to copyright infringement? So you ask yourself 2 questions, right? Is the use you are contemplating infringing copyright? Okay, so does it not fall under open access, a CC license, etc.? And assuming that copyright subsists in the work, then you move into the second part of the analysis. Realizing, of course, that we do have those exceptions to infringement that can apply, and fair dealing is the one we usually go with. It's usually the broadest, and it is considered, as I said, a user's right. So it has to be for one of the enumerated statutory purposes. We've already really covered this, right? It falls under education if we're talking about OER pretty clearly, right? So we meet that first boundary, and then we move into whether or not it's fair, right? So what is the purpose? Education. What is the character? It might be nonfiction or fiction work, the amount of the dealing, and there's no bright line for this. So we hear a lot about, 10%, et cetera, et cetera. Well, there's no bright line. Nowhere says, this is a fixed amount. So that's going to be a bit of a sliding scale. Are there alternatives to a work? Is there something else that you could have used that is in the public domain, or is an open access work or whatever? What is the nature of the work? Okay. And then again, the effect of the dealing on the work. Okay. So is this actually, would somebody not buy the original because they're using this? So again, this isn't just a checklist where all 6 factors have to be satisfied, right? And this applies to the 4 factors as well. It's a holistic evaluation, and it's going to be made based on all of the facts and circumstances. So I know that people are frustrated because there aren't bright lines in copyright, but really it's a good thing, okay? Because it means the courts are going to look at each instance with fresh eyes. And deal with it based on the very facts of the case in front of them. So this is the other thing that I wanted to bring to your attention, this Code of Best Practices and Fair Use for Open Educational Resources. I have a link here. I will put it up on my SCED. And this was also created through a group of professors through the American University, Washington School of Law. And it's a terrific resource just for best practices. So some of the ways that you can mitigate risk is that course materials for which fair dealing are going to be claimed should be posted on course management sites that limit access to currently enrolled students rather than being posted on the open internet, or just a closed portal, perhaps. Resources that are already licensed by the university should be used whenever possible by way of a direct link. Primary legal materials, there's plenty of open access resources. Here in Canada, we have CanLII. There's also one in the US. Use materials that are in the public domain or under a Creative Commons license whenever you can. Encourage students to link to online resources directly, and ensure that students understand the limitations that are on the materials that they are being given access to. So those are just some of the things that we mentioned to students. So what did we learn throughout the last year and a half or so? So in April of 2020, we had this case come up at the Federal Court of Appeal here in Canada, University versus Copyright Licensing Agency, or Access Copyright. I'm going to come back to that one because we get a ruling from the Supreme Court of Canada in 2021, which was very helpful. In May of 2020, we had Black Lives Matter. And of course, what that taught us was we needed more education, more access to education, and access to culture and access to history, to be able to understand, other cultures from our own, and to be more receptive and more responsive. So that was one of the things that taught us, right? That we were taught in May of 2020. In June of 2020, we had the publishers suing the Internet Archive, which is a controlled digital lending library. And this goes back to my point about technological neutrality, right? So for every book that they have that they will loan out, and they'll loan them out for 2 hours, or they'll loan them out for 2 weeks, depending on the particular book, they have a physical copy in a warehouse. They only lend that one copy out digitally at a time, whether it's 2 hours or 2 weeks. Now, they loosened those restrictions during the pandemic, okay, so that they could serve more people. I just actually had a course that I was teaching, and one of my students was in Trinidad, Tobago, and she could not find a copy of Hamlet for love or money, and I sent her to the Internet Archive, where she could, basically take it out digitally. Okay, that was really her only option to be able to participate in the class this fall. So, that's an option that's out there. This particular case has not been settled yet. I'm hoping for a good result on this one. In July of 2020, on June 22nd, President Cyril Ramaphosa referred the Copyright Amendment Bill and the Performance Protection Amendment Bill back to the National Assembly. It looked like things were going very well, but unfortunately, the USTR got there. So this is the most recent example of the USTR's influence. And this is, not an unusual thing, right? So the USTR's concerns here stem from a number of American media organizations, the Association of American Publishers, the Entertainment Software Association, the Independent Film and Television Alliance, Motion Picture Association of America, and Recording Industry Association America. And in fact, intruding into other countries is a regular occurrence in trade negotiations. As I said, these lobbyists are able to push their agenda, and the trade negotiators on all sides of the negotiation table are unlikely to be experts in intellectual property, let alone the process of creation and innovation. The negotiators are skilled at negotiation and will try to find the best deal they can based on how lobbyists have betrayed the value of their interests. So maximizing their profits allows media companies to do three main things that affect author creators and our access to educational materials, our access to culture. Firstly, allows them to buy content relatively inexpensively as authors, creators, particularly those starting out, are in the weaker negotiation position. Authors, creators need to make a living in order to keep creating and innovating, and they want to reach the largest possible audience. Okay, the carrot of becoming the next Stephen King, George R.R. Martin, Taylor Swift is followed by the stick of industry-skewed contracts. To further factor here is that media conglomerates have the most expensive lawyers on retainer to ensure that these contracts are the most advantageous to them. This leads to the second factor. Media conglomerates can afford to go to court. It's expensive. They do it all the time. They know the system and they know how to win. The average creator and user have likely never had any need to hire a lawyer. They're likely nervous of lawyers and the law, and they're likely unfamiliar with both. I refer you back to my risk aversion of university administrations. Even though they are lawyers and they go to court, they know to be adverse. So artists and users are more likely to raise their voices if they understand their rights and the law, and they're comfortable in defending themselves and assessing when to get help, the help of a lawyer. The third effect of the deep pockets of media conglomerates is their ability to influence the law itself through lobbying, as if the huge media conglomerates weren't enough in and of themselves. In the lobby sphere, it's the industry bodies such as the Motion Picture Association and Recording Industry that combine these media conglomerates into an even more effective wedge. So corporations with deep pockets, and especially industries with organizations with deep pockets and common goals, can afford to pay for the best lobbyists to influence a policy that feeds into both trade negotiation and legislation. So all of these things then factor into our access to education. Whoops, now what's going on? There we go. Hopefully you can see my screen again. Okay, so now we move into September of 2020. Now here you go again, you say you want your freedom. Well, who am I to keep you down? So COVID-19 resulted in more people spending more time online than ever before. We weren't just learning in school, we were learning everywhere. So people turned to alternative methods to entertain themselves. A recent study revealed that TikTok has an estimated 800 million monthly active users. And one of the important major differences between Spotify and TikTok is that TikTok directly inspires creation through dance challenges videos. Perhaps the most salient example of TikTok's power is Nathan Apodaca's video here in October of 2020, well, September, of him riding his skateboard to work, drinking ocean spray, cranberry juice, and dubbing Fleetwood Mac's song Dreaming. So this short video actually resulted in a number of copycats, including celebrities and even Mick Fleetwood shown here. But most importantly, it resulted in the 43-year-old Fleetwood Mac song rocketing to 21 on the Billboard Top 100. And the song also had its best download and streaming sales in its history. So there are now 50 million content creators, okay? This is 2021. This is the world we now live in. People are educating themselves, okay? It's not just happening in schools. Open educational resources, as I've been saying, aren't just happening online in schools. So April of 2021, Google and Oracle went to the Supreme Court. The history here, there's two issues in this particular case. First of all, it was whether the API code was copyrightable. And the second issue was Google's use of it, whether or not that was fair. So the history here is that Java originally was developed at Sun Microsystems, and it was released to the public in '95 under the Sun Community Source License, making the source code freely available, but requiring that products using the code were maintained to the Java standard, and that any commercial derivative works were licensed by Sun. So Google initially approached Sun for a license, but they couldn't come to an agreement. Oracle then bought Sun, and then the dispute centered on the use of the parts of the Java programming language application interface, and included about 11,000 lines of code, which were owned by Oracle. So the court actually sidestepped the copyrightable questions here, but in a 6-2 decision, they declared Google's use fair. And it's important to note that Google won on all 4 of the factors. I promised that we would come back to this. In July of 2021, we also got a decision in the York University versus Canadian Copyright Licensing Agency. Access Copyright is a collective society gathering royalties for authors. They issue licenses for use of works in their catalog. The rate of licenses or tariffs is decided by the Copyright Board of Canada. And the dispute began in 2010 when York University and several other universities refused to pay the tariff. The reason being that Access Copyright wanted to raise the tariff from $3.38 per full-time student to $45 plus additional royalties for course packs for full-time at each full-time equivalent. You heard that right, $3 to $45. So there were 2 issues before the court here. First of all, is the tariff mandatory? The courts decided that no, like any license, it can be available, but the tariff is not mandatory. It's important to note here as well that nobody was getting anything for free here, okay? Royalties were being paid through databases that the university was paying for through the library system. The second issue was whether or not York's use was fair, but once it was established that Access Copyright did not have an exclusive license to any of the works at issue, they no longer had standing in the case to argue that. But the court did weigh in with a few comments, and I will hopefully cover those very quickly. So these are just a few quotes from the decisions that I thought were pretty important, and I just wanted to point them out. In the Google case, copyright grants an author an exclusive right to produce his work, not as a special reward, but in order to encourage the production of works that others might reproduce more cheaply. At the same time, copyright has negative features. Protection can raise prices to consumers. It can impose special costs, such as the cost of contacting owners to obtain reproduction rights. In the York case, increasing public access to and dissemination of artistic and intellectual works, which enrich society and often provide users with the tools and inspiration to generate works of their own, is a primary goal of copyright. We're seeing that educational component and research components shine through in these, right? And York at paragraph 71, instead of operating as part of a scheme designed to control collective society's potentially unfair market power, Access Copyright's interpretation would turn tariffs into a plainly anti-competitive tool, boosting collective society's power to the detriment of users. Again, Google's basic objective was to permit programmers to make use of their knowledge and experiencing using the Sun Java API. In a sense, the declaring code was the key that it needed to unlock the programmer's creative energies. They not only pay homage to the programmer's education here, they celebrate it. They go on, given programmers investment in learning the Sun Java API to allow enforcement of Oracle's copyright would here risk harm to the public. And then York, Justice Abella in that decision looked at the main problem with the analysis of the Federal Court of Appeal was that they approached the fairness analysis exclusively from the institutional perspective. This error tainted their analysis of several fairness factors by anchoring the analysis in the institutional nature of the copying and York's purported commercial purpose. the nature of fair dealing as a user's right was overlooked, and the fairness assessment was over before it began. So again, the correct way to look at this, these facts, was from the student's perspective, right? Nobody was getting anything for free, and it was helping students obtain materials in a less rapacious way, perhaps. And I'm just going to skip over this particular slide. In July and September, through to September 30th of 2021, we had the discovery of a number of mass graves at residential schools in Canada. This led to the declaration of the National Day for Truth and Reconciliation as September 30th. So like Black Lives Matter, here was another marginalized group that had their history and culture stolen and silenced. Much needs to be done, but it needs to be in consultation with the groups involved, right? How do they wish to share and preserve their culture? They already have cultural approaches to sharing information and educational practices. And I think these things need to be honored even as we try to bring these materials into open educational resources. There's ethics here. This was covered really well in a previous session. So in the fall of 2021, I opted not to use a writing handbook for my writing class because I discovered the cost was going to be over $90 in Canadian dollars. Okay. It was like a little floppy, spiral bound handbook, which would have been a nice aid for my students, but I wasn't going to make them pay $90 for it because Purdue University has a wonderful online open educational resource that covers documentation and grammatical issues and all sorts of things there. My business law text that I get through Pearson is a 2020 copyright. It's required by my chartered public accountant approved course. It is not actually available in print. They can't get a hard copy if they want one. They can get a 180-day subscription for $50, and then they no longer have access to it. If they actually buy it through the Pearson website, they can get it for a whole 12 months for $50, but through our bookstore, they're only being offered 180 days. Also in December of 2021, this is just very recent, there was a news report that Pearson's average library ebook is going up by approximately 500%. So, publishers are trying to, push back against what is hopefully a wave of open educational resources. And certainly, in addition to other forms of OER, open access materials and things, people should not be concerned about or should be embracing the user's rights and the educational purposes behind copyright. So copyright does support OER's core purposes. Public interest goals are served by fair use and fair dealing. Opponents need to be persuaded that their attempts to lock down content is not in their best interest. Again, I send you to the dreaming TikTok, okay? It is in their best interest to foster educational tools and educational uses of content. That's their new creators coming around the corner. Education needs to be very broadly interpreted, and we need to do more to curb the influence of lobbying. Lots needs to be done in that policy space. And we also need to rely on the courts who really do appear to be on the side of public interest goals. And that's all I have for today. Any quick questions?
Hi. Well, I had a few, but we're going to run out of time, so because we're going to get kicked out of the space.
We have 3 minutes.
Okay. Well, the background to my question is that I used to be copyright librarian until very recently. So at the University of Ottawa. So everything you talked about was like, oh yeah, okay. But something that comes up a lot, and that's also true when we talk about fair dealing and fair use, is that a lot of people don't feel comfortable turning to it for OERs. And a lot of it has to do with, or even if their institution seems to be like not as risk averse, although mine tends to be. But
and you have Michael Geist.
I know, but yeah, I know it's ironic, but he's not a lawyer for the university, so. So the worry is about like kind of downstream use. Like, what if I like include this in an OER and I say it's, I did it for fair use, but that part like will not fall under the Creative Commons license I'm applying for the whole like resource that I'm creating. It's like something separate. I'm not going to change the original copyright like status of that thing. But yeah, people are worried about the downstream use and how people are going to interpret it, that it's going to be used as if it was under a Creative Commons license. I don't know if you have anything to say about that.
A disclaimer.
Yeah, that's
yeah, easiest thing in the world, right? And it's a matter of education.
That's what I suggest, but like some people don't feel comfortable with that either. But yeah.
Well, I mean,
Sorry.
you can only, instruct your students on how to use the materials, right?
Yeah.
And as long as it's, the disclaimer is listed somewhere in the materials, I mean, you can only cover yourself, right?
Mm-hmm.
That's really the most anybody can really do.
Exactly. Like how much you're